Hello and welcome to the channel, guys. Good news for students, bad for hustle. Subscribe to the channel, guys. Like, share and comment, please. Thank you. Court orders ASU to call off strike. The National Industrial Court ordered the Academic Staff Union of Universities ASU to go back to work. The federal government, in a suit, prayed for the order for ASU to call off its 7-month strike. The Minister of Labor and Employment, on behalf of the federal government, had filed the matter before the court by way of referral to resolve the issue of the ongoing strike by ASU. Mr. J.U.K. Igwe, son, counsel to federal government, in a submission had informed the court that the application for the injunction was dated September 12 and filed same day. He added that the application was brought in pursuant to the rules of the NICN 2017 proceeding. Igwe further stated that it was predicated on 11 grounds supported by 21-paragraph affidavit deposed to Mr. Okechukwu Wampa, a legal advisor in the Ministry of Labor and Employment, attached with 3 exhibits and an undertaking as to damages deposed to by Wampa. He also urged the court to grant the prayer sought and proceeded to adopt in its entirety and totality the written address, adding that the claimants had met all the requirements to enable the court to grant the injunction. He cited that claimant's action was not apprehensive, and regarding damages, he said the lost time of 7 months of the strike could not be regained. He concluded by saying that going by the provision of Section 18(1)(e) of the Trade Disputes Act 2004, that a worker should not embark on strike when a matter is already before the court, urged the court to grant the injunction. Mr. Femi Falana, son, counsel to the defendant, stated that he had before the court a 9-paragraph counter affidavit filed on September 16, deposed to by the president of ASU. He further submitted that attached to the affidavit was 8 exhibits accompanied by a written address, and proceeded to adopt same as their argument in opposition to the interlocutory injunction. Falana, in addition, argued that the minister lacked the power to order the court in the referral to direct ASU to call off its strike. He averred further that once a referral was before a court, no party could go outside of it. Falana, in his argument, also pointed out that the claimant did not follow due process in Part 1 of TDA 2004 that stipulated that only an individual has the right to approach the court as a trade union will first need to go to Industrial Arbitration Panel IAP before coming to the court. He said union can only approach the NICN to appeal the decision of IAP. Falana also said that the letter that accompanied the referral had the name of the Attorney General as a party in the suit, but that, however, the application filed before the court was without the name. He also said that the referral asking for accelerated hearing was not necessary, as there was not urgency in the matter as the strike had lasted for 7 months. He also submitted that the balance of convenience was not on the side of the claimants, and that the conduct of the claimant in the prayer for the court to interpret the 2009 agreement should be discountenanced. He finally urged the court to dismiss the application or direct parties to the IAP. Ensure to hit the subscribe button, guys. Like, share, and comment below. Thank you. Meanwhile, the Academic Staff Union of Universities ASU has reacted to the order by the National Industrial Court of Nigeria NICN that asked its members to call off the 7-month-long strike. The union, in a statement signed by the Lagos Zonal Coordinator, Dr. Adeleja Odukoya, quoted the national president, Professor Emmanuel Osodeke, as saying, "Our lawyer is filing an appeal and stay of execution of the judgment." According to the statement titled NICN Back to Work Order on ASU, Be Calm, Osodeke urged the aggrieved university teachers to remain calm as there is no cause for alarm on the back to work order delivered earlier today. Members should remain resolute and strong. A people united can never be defeated. Solidarity without compromise, he stated. In a similar development, the National Association of Nigeria Students (NANS) has described the Industrial Court judgment as a black market judgment. The National Student Body spokesperson, Giwa Temitokpe, described the NICN ruling as a black market judgment. Temitokpe said the ruling lacked equity because the federal government should not have taken ASU before the industrial court from the beginning. He explained that the only solution to the ongoing strike is for the government to meet the demands of the union, which they willingly entered into with ASU. Our attention has been drawn to news of a court judgment mandating the Academic Staff Union of Universities (ASU) to call off its 7-month strike. As an association, we feel disturbed to read the news of the judgment because we believe that it betrays equity. Ordinarily, the federal government is not meant to have dragged ASU to the industrial courts, but the fact that they had to drag ASU to court is a signal that this government cannot handle crisis, and we want to state categorically that the court cannot force members of ASU back to lecture theaters. And as it stands today, with that court judgment, we maintain that the court has not resolved the problem and we reject the judgment in strong terms. The court could have said that the federal government should go and pay rather than say that lecturers who are on strike should go back to classrooms. We were expecting the court to have understood that lecturers are on a contract of personal service, hence, they cannot be compelled to render a service they don't want to render. The only remedy to this strike action is for the federal government to accede to the demands of ASU, which the government willingly entered into with them, and properly fund education, Temitokbe stated. That's a wrap of the news, guys. Bye.